Good morning, afternoon, and potentially evening if anyone's joining us from overseas. Thank you all so much to Nova for the invitation. I really appreciate the synergy and the connection that the military side has with our civilian partnerships, because as we will discuss, oftentimes a fair amount of our clients that we help to advocate for on the military side are civilian victims, dependents. And so they often use the services that you all provide in the civilian sector, either independently or in conjunction with the military side. So I really appreciate the invitation. And thank you all. Open to any questions in the chat as we go through the presentation. And with that, I will begin. This is a military. If any of you all are prior military, we have to tell you what we're going to do it and then tell you what we did. And it's going to provide you a little introduction as to who I am, a little introduction to the military justice process. It works in some ways very similar to the civilian sector, but in some ways it is a little bit different. And then unique challenges facing military connected survivors. That's both persons that wear the uniform as well as the dependents and those that are connected with the military life. So first, just as a general overview about myself, I am currently, for the next one more month, the Chief Victims Counsel in Districts 3 and 4 of the United States Air Force Victim Counsel Program. We are divided into 6 districts. I essentially cover all of the middle of the United States is probably the best way to say that. I supervise 33 attorneys and paralegals that range everywhere from California to Mississippi. Prior to this assignment, I was a prosecutor. I was an on-the-ground victims counsel. So right now I'm in more of a leadership role, but I've been a victims counsel out in Albuquerque. I've been an instructor and I've done regulatory law. So I've seen the creation of the Victims Counsels program. I'm happy and honored to say I was one of the very first victims counsels that the Air Force started it, and one of the first victims counsels that the Air Force had back in 2013 when we stood up, and now coming back in this leadership role. And I don't think I see anything in the chat, so I will continue. So the first thing that I wanted to jump into are just some unique considerations for military connected survivors. For anyone that may have been prior military, either on active duty or connected with the military, the one thing that is true for most people is that military life is transient. What I mean by that is that we are always on the move. I joined the Air Force in 2012. I will be moving to my 5th different state and 2nd country in the last, 12 years. My son is 9 and has lived in 5 different states. And so because of that, there's a high possibility of isolation. That's both stateside as well as abroad. Some people think that, oh, if you're in the United States, then you should be able to make friends. And yes, that is an assumption, but it can actually be more isolating, especially if you are unfamiliar with that area of the country. I saw I think it was TikTok, I'm not very computer savvy, but they were talking about how people that live in foreign countries talk about how much they travel and visit all these other countries. And that's because you can travel 45 minutes and be in 5 different countries. But the United States is all the countries in one place, and you can travel around and be in a completely different place at any point in time. I currently live in San Antonio, Texas, and it is a completely different world in San Antonio than it is in even Dallas. And finding people that you can connect with can be very isolating. And then obviously, if you are Oconus, if you don't speak the language, then it is difficult to find not only a community, but those resources off base, because there may be that significant language barrier. That's just something to think about as you all are helping survivors to navigate spaces, is that not only may they feel isolated within the military context, but also just generally within the society in which they live as a whole. Part of the isolation within the military context is military jargon. We unfortunately have acronyms for everything. We have acronyms that literally don't mean anything. For example, we have something in the Air Force, actually maybe DOD-wide, called the CATCH program. And that is to help essentially identify serial offenders. CATCH stands for absolutely nothing. I think it just sounded catchy. The objective was to catch these serial offenders, but it stands for nothing. And without being within the context of either victim advocate, victims counsel, prosecution, the sapper world. There's no way to really know that. And so that can be very hard for people to break through. And we understand that. We try to make sure that we can explain things. That's literally the job of the victims counsel, is to explain things in a way that hopefully everybody can understand. I've represented over 100 clients in my time as a victims counsel, as well as the chief victims counsel now. I will tell you that whether my clients are very junior kids, junior, and I say junior, like 18, 19-year-old young officers, young airmen, all the way up to the most senior colonels, for example, there's still a lack of complete understanding about every aspect of the military justice process. And so that's why it's really important for us as victims counselors to help translate that. On the military side, other considerations are career implications. Military life is transient as it is. If you are a survivor, you may not want to stay in the same location where you are. We have the expedited transfer opportunity, but now you have to uproot you and possibly your entire family and go to another location, build that rapport with your commanders and with your colleagues so that you can hopefully continue your upward trajectory in your career. As with, I imagine, some careers outside of the military, but definitely in the military, we have career fields that are very small. One of my first clients was a parachute packer. There were 4 or 5 installations where her job could actually ever take her. And so she could move around, but only within a 4 or 5 base range. That makes not having what happened to you impact your career very hard to accomplish, or at least to have someone who is not going to know about your situation. That's a lot harder to do. Now, we have the Space Force. The Space Force is located at, I think, 3 to 4 installations. Lears, for example, those that work on our missiles, those are 4 or 5 installations. So those are things to think about if you're assisting those that wear the uniform. When we say, oh, you can just X, just know that is usually a lot more complex than it may appear. When it comes to navigating helping agencies, we have a lot of them, and for that, I'm very thankful. However, each one kind of does a different thing. Our SAPR, our sexual assault response coordinator, which you may refer to as they handle sexual assaults. Family advocacy is domestic violence. However, domestic violence very well can include sexual assault. Family advocacy cannot represent children. The sexual assault response coordinators cannot represent children. And so understanding who goes where and who can help whom, and even who has what privilege can be difficult. So we put this out there not to deter anyone from doing anything, but to just know that there are a lot of unique considerations when dealing with military connected survivors. And if there's nothing else to take away from this presentation, is that there is literally someone whose job it is, Air Force Victims Counsel, Air and Space Force, and they have the same service in the Army, the Navy, and the Coast Guard, and obviously the Marine Corps as a part of the Department of the Navy, to help survivors navigate this area. The goal is so they don't have to do it alone. And I'll just stand by for a second for any questions. I don't think I see any in the chat. Okay. This provides a little bit of context. I was asked to give everyone just an idea of how the military justice system works out. So I wanted to start with the base legal office. So if you hear people say, go to legal, what they are talking about is the base legal office. Every single installation in the Air and Space Force has one. And that office is always headed by usually a major, someone of my rank that's been in minimally 10 to 12 years, but generally a lieutenant colonel. And that person is like the partner of that individual law firm. That person should generally be aware of everything that is going on in their office, and especially when it comes to the investigations that their office has jurisdiction over. And so if there's ever something that is like, we need attention to it right now, and it is something that cannot wait, then you're calling the base and asking for the staff judge advocate for that particular office. That person has two, part of the, what we call the leadership triad in the legal office, will be a superintendent, which is usually the most senior enlisted member of that office, as well as the deputy staff judge advocate, who will be the second person in control of that office and will generally should have the same, if not more, knowledge about the situations than the staff judge advocate. The persons that will actually try the cases, the ones that will be in charge of the day-to-day operations, of gathering information, of doing the prosecution, are the assistant staff judge advocates. And these are going to be our more junior attorneys. Our job as leaders are to grow and develop and train them, essentially to replace us, to be the future leaders of the Air and Space Force. But they are young. And so we ask people, if you are talking to an assistant staff judge advocate, know, and especially if you are an attorney yourself and you're trying to convey something, just know that you may have to think back to where you were when you were just entering the legal profession, and not assume that the person you're talking to will have this great wealth of 10 or 12 years of litigation experience. They may just be starting out. I'm happy to say the Air Force JAG Corps is one of the hardest ones to get into. And so we take the best and the brightest, but experience is a necessity. So if you ever feel like you're not quite conveying something or they're not quite understanding, that's when you just ask to possibly speak to the deputy staff judge advocate, who will have a little more experience. And then our case paralegals, I tell people all the time, nobody can do anything, no attorney can do anything without our paralegals, because they are literally the ones that understand the technical aspects of getting things done. They won't litigate, obviously, but they'll be able to tell you exactly how we do almost anything when it comes to the processing of cases. And those persons are always enlisted members. Any questions just about the construct of a base legal office?
There's not a question about the structure, but there is one question. Where will you be after next month?
I will be moving, thank God, to Colorado Springs, Colorado, where I will be the deputy staff judge advocate at Peterson Space Force Base.
Awesome. So thank you.
No, thank you. I'm very excited. I'm currently in San Antonio, where it was 117 degrees as a heat index 2 days ago. And I am very happy to be leaving soon to find weather in which I can breathe. So, yes. All right. Okay, so the next area I want to talk about, so we talked about the base legal office, is generally the command structure. And so we're talking about military connected survivors. So that means somebody is either going to be in the military or connected to someone that's in the military. So I wanted to provide just a brief overview of how most commands are set up, understanding that it can be, especially outside of the Air Force, we are much smaller in the Air Force than the Army and the Marine Corps when it comes to their command organizations. Our commands can range anywhere from 50 to 100 people to thousands of people, to several hundred people. But generally, there's always going to be a commander, a squadron commander. The Space Force now has Delta commanders. There's going to be a commander whose job it is to make sure that good order and discipline are first and foremost for that unit. That will be the person that can take action. That can be the person that will essentially initiate the military justice action outside of the court environment. When you want to know who it is that has control at all times over a particular military member, it is going to be that commander has essentially a team that sits outside of his legal office. That means outside of his or her command, that will be the legal office, that is their legal advisor, and then law enforcement. And so if you call the commander directly, it is possible they're going to say, I need to talk to law enforcement if it's about an ongoing investigation, or to the legal office if it is about a case that is underway. They will be the initiating person, but they're likely not going to have the latest updates, because once they initiate it, they're out of it until we pretty much get to court or there's a resolution. But they will have day-to-day control over that member. If there are threats made, if there are violations, the command team will be the one that will need to take immediate action. They also have a leadership triad, and their essentially right-hand man or woman will be the first sergeant. or the shirt. This is a nickname given to usually a master sergeant. First sergeant is a position in the Air Force and the Army. It is actually a rank and a position. But that person's job is to have their finger on the pulse of the unit, both from a mission success standpoint as well as a personal standpoint. So I would put to you that if you need to ever get in touch with someone at the unit, or you need to advise a survivor on who to go and talk to if they need some action taken, they feel like they're not being seen or heard, then the first person they should be going to is that first sergeant or shirt. And then that first sergeant or shirt sits in the leadership kind of wing of any squadron, but they'll have a first line supervisor unless they are themselves the frontline supervisors, in which time they would report to the commander or the superintendent. But generally, if we're talking about, a lot of our clients are teen to 22, 23-year-olds. They're not going to be the supervisors. They're usually going to have someone that's a little more experienced. So that's a general construct of any sort of particular squadron. It could vary depending on just how large or small it is, but that's generally the structure that is there. I'm sorry, scrolling down to see, is this information applicable to all branches? Generally, it is applicable to all branches. It just may look a little bit different and will definitely have different names. So say in the Air Force, we have squadrons. The Space Force has deltas. And then you get to the Army side, and I'm going to probably start embarrassing myself, but I know they have like garrisons and battalions, and they have different names. In the Marine Corps, I know there's something called a MEF outside of that. Dr. Ramirez, if you wanted to, I know that there's slightly different names even for the Marine Corps. Obviously, the Navy is on ships, but every commander is going to have a right-hand person that is enlisted and another person that is going to be their deputy for times in which they are not. And then you always have frontline supervisors. They just may look a little bit different based on the size of the actual organization. Hopefully that helps. Okay, and I think somebody may have a hand raised. Oh, I'm told to put it into the chat. Okay, I will see if that comes into the chat. All right, I don't see anything yet, but please go ahead and put that in there if you have any questions. Okay, so we've talked about the structure of the legal office and structure of a command generally. This is, and I apologize, it is a bit of an eye chart and some of the lines go to different levels, but this is the life cycle of a military justice case, generally speaking. Just to take back and give you just an overall big picture. From the time an allegation is reported until the time that it sees trial, that is likely minimally going to be a year. Can they go faster? Yes. Do they generally go faster? No. If you're saying to yourself that is a long period of time, yes. And for the survivors, that is probably feels even longer. But I will tell you that in the military side, cases in the military side go much faster than cases on the civilian side. I said, I'm heading to trial. I was telling fellow presenters earlier today, I'm heading to trial in a couple of weeks, a case that has been going on for about a year. So right on the expected timeline. I also represented a client whose case was in the civilian sector who have been ongoing for 4 years. So yes, it is a long time, and we do not want to pretend like that's not a long time for a survivor to be waiting for justice. But just know that it is very short compared to some of the cases that we see on the civilian side. So with that, starting with the allegation of the offense, that can come, frankly, a lot of different ways. It can come directly from the victim to our military law enforcement agency, which is for the Air Force is the Office of Special Investigations, for the Navy, NCIS, and the same thing for the Marine Corps, for the Army, CID, Criminal Investigative Division, and for the Coast Guard, CGIS, Coast Guard Investigative Service. I think someone's in the Coast Guard and wants to correct me, but I think it's CGIS. And generally they are called MCIOs, Military Criminal Investigative Offices. You can make a direct report to those offices. Or, as what often happens, clients will go to SARC or will go to FAP, will go to the Sexual Assault Response Coordinator or to the Family Advocacy. In the Army, I know it's called SHARP, but the Sexual Assault Response persons or the Family Advocacy persons. And then they can make the initial report there. And then from there, those offices will let the military investigative offices know that a report is coming. And that's how that will start. The next step is going to be the interview. Very rarely, and I hate to say never because in law you usually never say never, but it's very hard to have any investigation start without actually doing an interview. A survivor can choose to make a report of sexual assault or domestic violence and decide to have it not investigated, and that will be a restricted report. So they can go talk to SARC, they can talk to FAP, and decide not to have an investigating. But if the goal is for it to be investigated, they will need to make that report. They will need to have that interview with one of the military criminal investigative officers. And they will do an investigation. That investigation can range. I think OSI generally says they have 75 days to complete an investigation. Understanding that sometimes investigations don't run that short. They can be much larger, especially if there are multiple victims involved, especially if people have moved around. So they need to go interview people on different continents, which is very often because of the transient nature of military life. So they try to do that, wrap that up as soon as they can. That might necessitate more than one interview with a survivor. As victims counsels, as attorneys, we try to prohibit that from happening. Nobody wants to have a client interviewed multiple times and making multiple statements. One, because that's more trauma to the client. And then from the legal side, multiple statements are never really a good thing. But sometimes it is a necessity. At the conclusion of the investigation, and while actually now the investigation is going on, as of December 27th of 2023, so last year, the Office of the Special Trial Counsel stood up. Now, because of them, or because of the standing up of that organization, they are looking at cases almost at the same time that the cases are being investigated, guiding the investigation, making sure that hopefully no stones are left unturned that would necessitate having to go back and do something over again. The Office of Special Trial Counsel has jurisdiction over a certain number of cases, which I will show you in the next slide. They also will make the decision as to whether or not a case that's under their jurisdiction we call it preferred, essentially that gets referred to a court martial. And the first step is a grand jury proceeding. But sorry, I went a little bit ahead of myself. C will help not help the investigation. They will oversee the investigation. They will provide inputs, and then they will have the discretion as to whether or not to go forward. Before any final decision is made as to whether or not the case goes to trial, victim input will be requested. And so this is, if a client does not have a victim's counsel prior to this time, which is completely possible, they can choose not to have one at all. But this is the time when usually we see clients come to us for referral because someone is asking them to decide whether or not they would like to participate in a court martial. In the Air Force, we do not force victims to participate, period, full stop. If they don't want to participate, they don't participate. If they want to participate, then that input is provided. Either way, it's provided to the trial team. I will tell you that it is very hard, if not impossible, to prosecute a case without a victim. And so because of that, if a victim chooses not to participate, oftentimes that is where a case will end. And for some survivors, that is the best way forward, especially when you consider, once again, going back to the military connected special situations, is that they could have very well have left that unit. They could have left that continent, be somewhere else, starting over in a new place, potentially with a new family, and does not want to have to go back to that place, especially if they are further along in their healing process, and this would bring them back. So we do not, as victims counsels, ever say you have an obligation to justice to make sure this person gets a day in court. We do not. Our job is to advocate for the express interests of our clients, and if that means not participation, then we advocate for that. However, if a victim does choose to participate in a trial and there is sufficient enough evidence to get and sustain a conviction, probable cause is the standard, but we also look at whether or not there's sufficient evidence to obtain and sustain a conviction, then that case will be preferred and referred to a court martial. There will be a preliminary hearing, which is essentially a grand jury hearing. And from there, the charges will be forwarded to what's called a convening authority for action. And now, after the stand up of the Office of Special Trial Counsel, that is the Office of Special Trial Counsel that will essentially be the vehicle for that going to trial. Once that happens, there are pretty much only two things left. There will be the case itself and then sentencing. But as part of the case, what started happening, I will say about maybe 7 to 10 years ago, is instead of having cases where you do the motions and the trial at the same time, most judges are recommending that we do what's called a bifurcated hearing, where we do the motions first, and then we come back and do the trial on a different day. The reason we do that is to hopefully prevent the cases from being delayed. If we can argue through all of the specific legal issues in a separate motions hearing, then by the time we get to trial, there should not be too many surprises and we can continue to go forward. Some of the worst things that can happen outside of the obviously assault itself is a victim gets emotionally and physically and sometimes financially prepared for a trial to go forward, and then it gets delayed for some reason, usually having to do with something very hyper technical. We want to try to avoid that if we can. So that's why we have a bifurcated motions hearing. One of the unique aspects of military courts is that we do trial and sentencing at not the same time, but one right after the other in the same week, the same weekend, whatever it is that it takes. We do not find someone guilty and then come back 4 months later for sentencing. If a jury or a judge alone comes back with a verdict on Friday at 5 p.m., then Saturday we're going into sentencing. If it's Sunday, they may take a break and go into Monday, but it will not be any more than 24 or 48 hours between the conclusion of a trial and, if there is a guilty verdict, the beginning of sentencing. Any questions on the life cycle of a military justice case?
We do have a few questions. One, is there a difference in the length of time for a case to progress through the military system for misdemeanors versus felonies?
It depends. So within the military context, we don't have misdemeanors and felonies designated as such. We have offenses. And if it is within the Article 120 umbrella, and what I'll do is I'll bring up this next slide just because I think this helps. If it's any one of these offenses, then it's probably going to take the same amount of time. When we talk about misdemeanors versus felonies, sometimes some of these, and definitely not murder or manslaughter, but sometimes the abusive sexual contact cases, which is part of the Article 120, those could be adjudicated at what's called a special court-martial, and a special court-martial is generally seen by outside courts as misdemeanors. But when it comes to the actual investigation of those, it may take the same amount of time. It just may go faster when it comes to the prosecution of it. But generally, we do not investigate crimes as misdemeanors or felonies. We do it all by offenses. And because of that, they generally will take the same amount of time. Oh, no problem.
I was just going to say thank you. We do have a few more. Let's see. Does this process change at all if the report is not made by the victim? I worked with someone who had a case start because the base found out about a civilian case and opened their own investigation.
That's a very good question. So Generally speaking, our legal offices are not going to go looking for cases in the civilian sector. But if the information is brought to them, especially is brought to the command, then the command has an obligation to essentially advise the the Office of Special Investigations that there is an allegation out there. But if the client doesn't want it to be investigated and does not want to participate, they don't want it to, if they don't want to participate, they don't have to. And that usually will lessen the investigation because they will need to have that information. The other piece is the military cannot, the JAG Corps for any service cannot prosecute someone for the same offenses in which they are without literally being granted permission by our most senior attorney, which is the TJAG, but cannot prosecute someone for the same offenses in which they are being prosecuted in a civilian jurisdiction. And because of that, there's really not much that we can do. There may be administrative action that can be taken, but there's really no point in the military trying to take that to trial because our rules will not allow that if we don't have jurisdiction. And if it's being prosecuted by the civilian sector, then the military will not have jurisdiction. So it's not impossible for it to be investigated. It just, especially if the client doesn't want it investigated, but it's not going to end up in court if we don't have jurisdiction. Hopefully that answers the question.
Thank you. Another question. How often is a survivor not notified of hearings as in civilian proceedings?
I will say that should never happen. Should not. If they have a victims counsel, that should not ever happen. That is literally our job. I'm not saying it doesn't happen, but if they have victims counsel, and I will tell you that if a case is proceeding to trial, the likelihood of them not having a victims counsel is very low because either they're a dependent, which means that they qualify. We also have a process called extraordinary circumstances request, which means that if you do not outright qualify because you are a civilian with no other military affiliation other than the important fact that you were assaulted by a military member, we have a process for getting victims counsel representation for those that are otherwise not immediately, that would immediately qualify. So I would say that in the military context, if a person has a victims counsel, that should never happen. And that will be grounds for a lot of not nice conversations with that victims counsel if that happens. I pride myself in telling my team their first job is to empower and advocate the victim. Their second job is to build relationships. And the only way that they can make sure that they don't miss anything is if they have a relationship with both the defense community as well as the MCIO community, as well as the legal offices. And it literally should not ever happen. Article 6B, which I can't remember if we talked about in here, says that the victims have a right to be informed. So when I say that it literally should not ever happen, it is written into statute. It is part of our job so that if that happens, a lot of people have actually dropped the ball.
Thank you.
Thank
And
you.
I will read one more and then we'll save the rest for the end. What happens in the case of a deceased victim, either as a result of the crime or they pass during the process?
That's a very good question. I'll say for cases like murder, for example, murder, manslaughter, where the offense can present this, I hope this does not come off as too callous, and I apologize, but just as a legal answer, if a case can proceed without a victim, we have what's called Article 6B representation, where a victim's counsel can be assigned to the family of a deceased member, and therefore representation can continue. If it is a case where there's testimony required for the case to go forward, for example, if it is a sexual assault case and the only two people that know what happened and there, or just say there's no other witnesses to the crime than the accused and the survivor, then that case will be hard to prosecute because we cannot just, for example, take the victim's interview and introduce it into evidence. Our Sixth Amendment of the Constitution requires that there be a right to confrontation. And unfortunately, if there's no one on the stand, then the accused does not have that right to confrontation. And because of that, the case likely cannot proceed to trial. But if there is a way for the case to go forward without having to have someone testify, then an Article 6B representative can be appointed for that person. Hopefully that answered the question and also was not too callous, but legally sometimes that is the only way that goes forward.
Thank you so much.
Thank you. Great questions. Thank you all. And Dr. Ramirez, if you can also let me know when I have 5 minutes, because I have a bad habit of running over.
Yes, of course.
Thank you. Okay. So when to contact the chain of command. You all are a part of the victim advocate and support community. And sometimes the only logical next step is to contact the command. Did I go back? I want to make sure I didn't skip a slide. Yeah, is to contact the command. What I will say is it's best to start with your sister agencies. If you are an attorney, please reach out to the base legal office, or if that person is represented by counsel, reach out to their counsel. Air Force victims councils love to talk to civilian councils because usually we can do better together and make sure that whatever is going on in the civilian world can either be bolstered by what's going on in the military investigation or vice versa. At least we want to make sure that we're not traumatizing the victim by asking them to do the same thing twice. If you are a sexual assault coordinator, domestic violence advocate, you're going to have sister persons and brother persons in the SARC world and in the FAT world. So I would reach out to them first. If it's something safety wise, where it's the client called and said there's a violation of a no contact order, what do I do? One is always call law enforcement. So if they're on the installation, call law enforcement. If they're off the installation, call 911. But beyond that, the law enforcement and command will be the ones to say, hey, I issued you, for example, a no contact order, or there's a military protective order and you're in violation of that. So now I'm going to take additional actions. Same thing with a civilian protective order, call the police first, and then the command to inform them of the fact that they're breaking an order, either from the commander or from a judge. When it comes to stuff like family support, and this is a lot of times where victims counsel and civilian counsel need to be on the same page, or at least an understanding of what each one can and cannot do. So there are very few times in which the Air Force is behind the other services. I love the Air Force. I do not want to throw shade on anybody else, but I do love the Air Force. But we are way behind, especially the Navy, when it comes to family support procedures. In the Air Force, the only thing that a commander can force a military person to do when it comes to family support outside of what a civilian judge may have ordered, is the difference between the amount of money that they get for housing with dependents and without. So if you just Google BAH, which is base, I forgot what it stands for. I just forgot. Well, we have our acronyms. I forgot what BAH stands for. If someone knows off the top of their head. Base allowance for housing. And there's a with dependent rate and a without dependent rate. And if you are getting the with dependent rate, then whatever the difference is between those two numbers, a command can order you to pay that to your dependents. For those that are not or not familiar with those numbers, it is the difference usually of $100. I'm a major that has been in for X amount of years, 12 years. Here in Texas, that's something like $2,200 a month with dependents. If I was single, it's $2,000. It is very small. So it's not a lot, and we understand that, but that's the absolute limit of what a commander can do. So understand that it's not enough to live on. In the Navy, it is they have it down to a science. How many kids do you have? What is your cost of, what is your BAH? This is how much you should be providing for your spouse and however many kids you have. We unfortunately don't have that. And so sometimes that's important for us, all the time. That's important for us as victims counsels in the Air Force to convey to attorneys in the civilian sector, so that when they're advocating to a court for why their survivor needs more spousal support, needs more child support, it may be an assumption by the civilian community that, oh, the military is going to make them pay X, Y, Z. In the Air Force and Space Force, that is not the case. That's something that you would want to reach out to the Victims Council for, so that we can make sure we'll provide you with all of the information, the AFIs, the Air Force instructions, the Space Force instructions, all the information to help you advocate to the civilian courts as to why they need to put something actually in place. Once an order is put in place, if a person violates that order, that becomes another thing. Because now we can say, I'm ordering you to follow this judge's order. If not, I can take any range of actions to make you do that. Any questions about that? I don't think I see any. All right. Military resources to mitigate safety concerns in an unrestricted environment. And so we've talked a little bit, just very briefly, about restricted and unrestricted reports. And so assuming that the command is aware of the issues going on in the home, whether that be domestic violence or sexual assault, then we have any of these opportunities available. Military protective orders, which are beneficial for those on the installation, as well as no contact orders, which prevents not only communication directly between the survivor and the accused, but also any third party. So you can't contact that person's mom to tell them anything. Expedited transfers, we can move a dependent survivor, we can move a military member via expedited transfer away from their abuser, whether that person be civilian or military, but especially if they're military. We can move people out of overseas assignments called early return of dependents. We can do that for those that are dependents. There's transitional compensation. Unfortunately, that's on the back end, so that's not something that can be done on the front end. But there is a significant amount of money available for those whose abusers are taken to court and a guilty verdict is obtained or is subject to discharge for sexual assault, domestic violence. Restrictions of movement. So commanders, one thing that they can do is restrict a member to base. That comes with some potential hazards on the court side. So if punishment is given to an offender to a case being adjudicated in a court, that could be seen as pretrial punishment, which could lessen the sentence that they get on the other side. So there sometimes has to be a balance there, but safety is obviously always primary. And then obviously we can investigate and prosecute subject to our jurisdiction. Important from, oh, sorry, I can't see the questions.
It's okay. They're in the Q&A. There's one question with what you just covered. Did you say you can do an expedited transfer for a civilian?
Not an expedited transfer under that particular provision. But if you are over, if it is a dependent overseas, and when I say overseas, that also includes Hawaii and Alaska, we can do something called early return of dependents to get them back to the United States. And we've actually had instances where it goes the other way too. So if there is a foreign national dependent and that person is in the United States and their entire support system is in pick a country, not the United States, we can send them back, not back, that doesn't sound like, we can send them if they would like to. We can provide financial assistance for them to go to their home country so that they will be surrounded by family the same way we would want someone in the United States to be. Within the United States, there are also, it's not an expedited transfer, but there are some grants available to help dependents to move out of situations so that they're not stuck there simply because of their financial limitations. These are one-time grants and they're actually through like Air Force Aid, for example. But within the expedited transfer realm, that unfortunately does not exist just for dependents.
Thank you. And just for your situational awareness, it's about 15 minutes.
Perfect, thank you. Okay, we're gonna press, and I'm sorry, I don't know how to get the Q&A up. All right, so I'm just gonna keep going. Someone can tell me. It's up now, but I still can't really see. Okay, real quickly, the difference between civilian protective order and military protective orders. It's that civilian protective orders, so these are ones issued by civilian judges, are good on and off an installation. These are the best. For all of my attorneys and victim advocates out there, I would argue to you that it's always best to have a civilian protective order along with a military protective order. We can help you get the military protective order. Usually we can get that very quickly, but it essentially survive the walls of the base, which means the security forces, the local civilian police force cannot do much with a military protective order. If someone says, why do we need a civilian protective order if we already have a military one? It's because we want all police officers to be able to assist if necessary. And that's the biggest difference. What the MPO, sometimes depending on the jurisdiction, will determine how fast a civilian protective order can be gotten. But usually military protective order, we can get that done within 24 to 48 hours. And no contact orders can come instantly. It's just, they don't have a whole lot of impact outside of that. This is just a quick breakdown of what victims. So I've been talking about victims councils. That's what we do. This is a quick little breakdown of what we do and what we can't do. Someone asked about representing deceased members. That's under our Article 6B, which is also Article 6B of the UCMJ now. Essentially, we will empower, advocate for all clients over which we have jurisdiction. We can advocate to any military entity. We cannot represent civilians in court. That is the big thing. One thing that I'm proud of is that in combination with our civilian sister services, NOVA, NCVLI, big props always to Meg Garvin, we're filing a lot more writs. We are trying to build the legal base for victims' rights. And so that is something that we have done, seem like we're doing almost once a month now. And it's our job to refer our clients to helping agencies. One of my own counsel is currently building an electronic book of resources in every state so that if unfortunately we can't help a survivor because of either they don't qualify for one reason or another, then we can try to at least guide them to some place that can assist. This is just give you a quick map. So wherever you all are in the world, this is a map of where all the Victims Council's offices are located. Sometimes there's one on every installation in that state. Sometimes there's not. And if you are next to an installation that does not have a Victims Council, one of these offices will be assigned. For example, I don't know if anyone is joining us from North Dakota. We have a Victim Council at Minot Air Force Base, but we don't have one at Grand Forks Air Force Base. But the Minot Victims Council is responsible for the Grand Forks area. So I would say as part of just your outreach, please reach out to your local installation and see who the Victims Council is there. They are also supposed to be reaching out to their civilian helping agency counterparts to make sure that there is some synergy there. We've talked about eligibility, or at least I brought up eligibility a couple of times. I won't go into this too deeply, but what I will say is if the person wears a uniform, they are going to be eligible for Victims Council services so long as it is something for which we represent victims. So if it is in the realm of domestic violence and sexual assault, then we represent anyone that wears a uniform, or if it's not us, it will be the National Guard for the particular services. If the person is military connected, so a dependent, so long as the person that is accused wears the uniform, then they would be eligible. Where we usually run into issues of non-eligibility is if it is a dependent that is assaulted by a local civilian, abused. Unfortunately, we don't have jurisdiction, and by me, the United States Air Force, DOD does not have jurisdiction over that civilian member. And since the Victims Councils cannot advocate in the civilian court system, there's very little that we can do. And so that's usually when we have to tell people, unfortunately, there's not much that we can do to assist. Like I said before, we have an exceptional circumstances request policy that allows us to represent those that would not qualify. So if you see at the bottom, it says non-affiliated civilian. Those are persons that are not dependents, not retirees, that don't otherwise have a connection to the military. They are not outright eligible, but if a case is going to trial, the likelihood they will be afforded the opportunity for a Victims Council is fairly high. I know I did that a little bit fast and I apologize. Like I said, this is for your resources, but please reach out to me, but also to your local Victims Councils for any other specific situations if you will have a question about eligibility. Okay, so the last thing here is our hypothetical. Dr. Ramirez, I don't know if people should be expected to have read it beforehand, but if not, I'll just take seconds and allow everybody to read that, and then we will go forward with the questions.
Yeah, and I can go ahead and read it. We did have it
Okay.
on the first day, and then you can take over at the questions. Adding on to our hypothetical from day 1, the first paragraph is the same. Service member Jones is active duty military and is married to Jennifer, who is not active duty or a veteran. SM Jones and Jennifer have 3 children, Mika 3, Cheyenne 12, and Dakota 18. Mika and Cheyenne are the biological children of service member Jones and Jennifer. Dakota is service member Jones's biological child and Jennifer's stepchild. Service member Jones is stationed in Alaska and lives on base. SM Jones has committed acts of domestic violence, including sexual assault against Jennifer. SM Jones has also stalked Jennifer, and both are now estranged, and Jennifer lives off the installation with 3 children. Jennifer has retained a civilian victims' rights attorney. They are considering reporting SM Jones's conduct to the relevant military investigative agency. They have not reported it to civilian law enforcement. The situation is causing Jennifer stress and anxiety, and they are overwhelmed by the idea of reporting alone. They are also concerned that once they report service member Jones's conduct to the military investigators, they will be required to stay near the installation until the case is resolved. Jennifer's civilian attorney has generally explained to them how a case progresses through the civilian and military criminal justice systems, but Jennifer wants to know more about what military processes look like from the court martial to just separation. They're wondering whether the process will disrupt the lives of their children and for how long. They worry about the effects of continued contact with service member Jones, even if it is through the court system. They share these concerns with their civilian attorney. They simply want to understand how the military system works.
And so I think you all are supposed to answer these. So what type of civilian supports are available to Jennifer during the military investigation and while the case is pending?
You can go ahead and write your responses in the chat. As an advocate, as a community member, what civilian support services are available? I see a yes. Yes to what? To the first question? I think they're answering both A and B.
I do. I see a lot of yeses, hotlines. I guess if I can add on to it, one, you all are a resource. For starters, you all are a resource. We do these trainings so that you will know how to hopefully explain the military situation or the military system, but also your sister service agencies and connecting them with the military SARC and SHARP programs, with the military family advocacy programs. Can Jennifer civilian victim advocates support in a military courtroom? Yes. Can you attend the court? If we make that a little more specific, can you attend a court martial? Absolutely. Can you get onto a military installation? That can be more difficult. I will tell you that for the most part, so long as you do not have any warrants out for your arrest, a victims counsel will be happy to sponsor you on to the installation. They are not hard to get. So long as you have a valid driver's license and insurance for your car, we will be able to sponsor you on. You just have to promise, please don't do anything, because we will get in trouble if you do anything while you're on the base. But yes, you can come and support. Can a civilian attorney represent them in a military court? I have never seen that. It does not mean that it cannot be done. I can tell you the reason why it can be done is because we have civilian defense counsels all the time. You are subject to the rules of an Air Force court the same way that you'll be subject to the rules of the court for your particular jurisdiction. The biggest issue is obviously that, assuming you're not doing it pro bono, that's something that the Air Force is not going to pay for a victim to have a civilian defense counsel, the same way the government does not pay for an accused to have a civilian defense counsel. But can someone do it? Yes, I have never actually seen anyone do it, but if there is someone that is willing to, obviously the pro bono, or a client is willing to pay for that service, then we can. There's definitely a space and mechanism. You would just be recognized by the court. You would put your bona fides onto the record. You're licensed to practice in whatever jurisdiction, and you are representing XYZ. There are other kind of questions in there that I just wanted to address quickly. Is anyone ever required to stay close to a military installation while a court is going on? Absolutely not. You can leave at any point in time. Nothing ever requiring you to stay. Is it easier sometimes? Yes. Just it's a lot easier to not have to fly in for the court, but interviews can generally be done virtually. Preparation for a court is usually better done in person, but there is no regulation that requires any civilian. The military cannot ever tell civilians what to do, period, full stop. We can tell you don't steal things, don't break things, but we cannot ever affect the movement of a civilian unless you're in a deployed or in a overseas environment and that country starts going to war, then we will pull you out and make you leave. Short of that, the military has no jurisdiction over what a civilian does or does not ever do. Impact of children when it comes to investigations. Unfortunately, we will try, and when I say we, everybody, there are only specialized OSI agents that are allowed to interview victims. We get specialized training in the representation of child victims. OSTC gets specialized training in handling cases involving children. So we try our best to make sure that we are as sensitive to the specific considerations for children as we can. At the end of the day, they still have to unfortunately do an interview, even though it is a specialized child forensic interview. They will still have to take the stand. We still have to take the stand. Although there are special considerations for children to do remote testimony if they cannot, if the trauma of testifying before the accused is too great. We have procedures within the military context for that. Can we completely lessen the trauma that it will take on them? Unfortunately, I don't think that anyone can do that. But there are ways that we can try to put up as many bumpers as possible. Is there anything I missed from the hypothetical, Dr. Ramirez?
No, that is all. We do have a few outstanding
Okay.
questions, but if you wouldn't mind, I can compile those and email them to you because we are at time, and then we can send those out to the attendees later on once we hear your responses.
If that
Perfect.
works for you, I'm available. That works for you. I may be a little bit delayed. I apologize in just getting it back only because I'll be in trial for the next 2 weeks.
Of course, completely understand. We just want to thank you so much, Major McCurry Dennis. Always such great information, a great presentation, and we just all want to thank you so much and
Okay.
hope you have a great rest of the day. For the attendees,